Good evening and welcome to Legal Tech Live, episode 90. I'm your host, Nick Rishwain, and our guest tonight is Jeff Rovner. Jeff is the managing director for information at O'Melveny and Myers. He spent 14 years as a practicing lawyer, followed by 23 years as a law firm technologist and knowledge management leader. His specialty is the artful application of technology to the practice of law. And he was invited because our community had asked, we need to talk to people who are in the law firms on the buy side of the technology that we're developing. Jeff, thanks for being here. I really appreciate you taking the time with me tonight.
Nick, it's a delight to be with you. Thanks so much for asking.
My pleasure. My pleasure. You came highly recommended from Greg Lambert of the Geek and Review podcast, and I really appreciated that. Our community, our audience had asked for input from what I would view as the enterprise side of law, right? The big law background. So you had sort of a framework in mind as to what you wanted to share. I want to let you do a little entryway into your experience, maybe a little background of your experience, and a little walkthrough in the entryway, a little entry here into your views on selling to big law, and then I'll work in some questions. I'll pep you with a few questions as well as we go there.
That sounds great, Nick. Thank you.
My
Well,
pleasure.
I'll start. As Nick was saying, I practiced law for 14 years. I was a partner at Morrison and Forster for several years. I was a transactions lawyer, and I was so bored by my practice, frankly, that I tried to systematize and automate whatever I could from all the repetition of my daily job, and that sort of became my hobby, and that hobby became my life, and I completely transitioned out of the practice of law back in 1996 to devote my time full-time to creating technologies to make lawyering easier. And I've worked in big law firms ever since, and I hugely enjoy being a technologist rather than being a lawyer. But I'm also keenly aware of how hard it is to sell technology to a law firm. We've got to be the most difficult customers imaginable across all industries. And so I think it's a noble duty to be able to offer my perspective on how I approach purchasing technologies, with the understanding that different firms have different ways of thinking. And even within a firm, different decision makers are going to approach things differently. Hopefully, my framework for thinking about purchases will be similar enough that it'll offer you something of general utility. And Nick, as you were saying, as I was trying to think when I heard this topic, I was trying to kind of interrogate my own mind of the process that I go through to get to the stage where finally I'm ready to make the licensing decision. And I've been able to distill that into 7 gates, if you will.
Yeah, that's great.
Yeah, so I kind of
People love a checklist or
exactly. It's an algorithm, right?
right.
So I'll give you the Rovner software purchasing algorithm. So I guess the first gate is to get my attention.
Okay.
So I get literally dozens of emails, texts, phone calls, LinkedIn messages a day trying to pitch some new technology to me. And there's just no time, without context, there's no time to devote to those. So I tend to pay attention to things that are brought to me by somebody I respect, so that I know it has already passed their filter and they know something about me, so that they are attentive to my own filters, and something that is working presumably well at their law firm. That kind of pushes it up above the threshold for me to devote time to it, because time is, obviously a scarce commodity. So that's the first gate to get my attention.
And in getting that attention, I think you kind of drilled into trusted source is helpful.
Trusted sources is kind of critical. You know, if I were to show you the 21 messages I received yesterday from technology companies, it would surprise you, perhaps, maybe not, to see how similar they would all look if you're looking at it from the perspective of someone who didn't set out to receive that message today, right?
Right.
So it's you know, it's tragic how so many good ideas go unexplored because they're simply not presented in a way that makes them ready to pay attention to. Yeah.
Makes sense.
So once you've got my attention, the second thing I want to know is your software addressing an important problem? And that's simply because given all the time it takes with a new technology to study it, to learn it, to research it, to test it out, to find a group of lawyers who might be interested in it, to get their attention, let alone to institutionalize it once it's been purchased, we have to pick our targets. Mm-hmm. And a technology that will address an important need of our firm and that will be used by as many lawyers as possible within our firm and will have the prospect of changing the business model of our firm for the better is one that is much more likely to get my attention than something that doesn't solve a really important problem. So solving important problem is critical.
And it sounds like when you say an important problem, it sounds like if I'm hearing it right, this is a significant problem.
Yes, it could be a do or die problem for a small group of lawyers, or something that is going to really change the day of many lawyers in our firm in a positive way. And I'll get some of the gates that come up will amplify a bit on.
Okay.
Yeah. Okay, so you got my attention. You're teasing me with software that's going to address an important problem that we have. Third, your software actually has to address that problem effectively, and you'd be surprised how often that test is not met. So if I think of the software as doing one of two things, either it is trying to replace something we already have, or it is trying to introduce new capabilities that we don't yet have. If you're trying to replace something we already have, you have a big hill to climb. There was a Harvard business professor named John Gorville who coined the term the 9 times problem. And what he meant by that was, if you are trying to sell a technology to replace one that your customer already has, your technology has to be at least 9 times better than the technology you're seeking to replace. His argument was, as the founder of your company, you are completely sold on what you're doing and believe it to your bones. And you are likely to overweight the value of your technology by a factor of 3. Your customer, on the other hand, is not going to see all of your technology. They're only going to see the delta between what you're offering and what they already have. But they're going to subtract from that anything that your technology doesn't offer that the technology they already use does, right? Things you may not have thought were features of the old technology, but have come to be used in ways that are useful. So Gorville's argument is, unless you're 9 times better, it's very hard to unseat an incumbent technology. The other thing is, a technology, has to be satisfying. It can't disappoint the user. And my threshold for disappointment is very tough. Lawyers who use something and find that it doesn't work as they expected, or they get a result they didn't expect, whatever, are very unlikely to come back. So you can completely lose the entire user base for which the technology is intended quickly if it's not simple to use and accurate. And by the way, in terms of accuracy, a lot of the AI tools that are based on natural language processing or supervised machine learning are probability based. So the answers that they give are statistically sound, but may be incorrect in any given case. And lawyers who encounter one of these tools and find a mistake will be very unlikely to come back again. unless a lot of attention is done in advance to setting their expectations and really demonstrating to them that notwithstanding the mistake, there's still a huge value. So for that reason, maybe that's the reason that we are the toughest audience. It has to be an effective solution.
Yeah, that's interesting. Almost if somebody who's got that attention to detail picks up on that a statistical anomaly, they're not coming back to it because I don't trust it to be 100% accurate.
Absolutely. There is a product that a lot of law firms and legal departments use called Serengeti. Serengeti is kind of an intermediary technology through which law firms send their bills to clients. Serengeti reviews them for client expectations, then passes them through for payment. And Serengeti actually arose from an earlier company called Elf Technology that was all based around a philosophy of software design that I've come to think is the right way to think about software design. And that is to think of the interaction between a human and their software as a conversation, right? So
right.
we come into the conversation with questions and we seek answers. We want to make sure we're understood. We want to, if a breakdown in the conversation occurs, because Nick, you use some phrase I've never heard before, and suddenly I'm now out of the conversation trying to figure out what you're talking about, then we have to be able to resolve that breakdown in the conversation smoothly, or else it's a very disappointing experience.
This is the idea of human-computer interface, essentially.
It is, but something by thinking of the interaction as a conversation, it raises the whole question of what makes conversations either joyful and in the flow so that you lose track of time, which is what we like, or uncomfortable or disappointing. And so that's the way I think about our own software that we built internally, is that it has to pass that test of being a satisfying conversation. Yeah. So, okay, so you got my attention, you've got an important problem, you solved the problem really beautifully. Next, I have to determine that your software can fit into the workflow of our lawyers, which is a whole separate question, right? So, you know, if our lawyers were like factory workers on an assembly line, this would be really easy. You know, you have a better tool to do one station on the assembly line. We buy it, we slot it in. The lawyer gets to that station. They use your technology. It's great. But as psychological animals, lawyers tend to be highly autonomous and independent. They have their own ways of working. They all have their own assembly lines. So we have to find a way to fit your technology into the workflow of a wide variety of different groups and tastes. And there are some things that turn out to be important about that. First, if you try to design an end-to-end solution to a big thing that lawyers do litigation, let's have a litigation platform that does everything you could want to do. I can promise you that software will not survive the first encounter with the enemy because there will be something missing in it or something that strikes a little bit of the wrong note. And the lawyers who are highly analytical will seize on that problem to the exclusion of all the wonderful things that your software does, and they'll discount it. So the lawyers in our firm and in most big firms I've encountered prefer tools to end-to-end solutions. Now, having said that, if your software only solves a highly specific problem, one that is just one task, say, in a much bigger workflow, then it's going to be very difficult for us to institutionalize, because the lawyer won't, when he reaches that moment in this big workflow, he won't think to switch gears and pick up your tool and use it, right? So a lot of the machine learning tools, supervised machine learning tools that are trained to do one very specific thing tend to fail in many cases in a law firm because they can't be built into the workflow in a way that causes the lawyers to remember to use them
Mm.
when the moment occurs. So, another kind of tough thing about.
That's almost part of the conversation, though, too, that you got to earlier.
Yeah,
Uh,
imagine, right, exactly. Because imagine if you're having this wonderful conversation and you mention the word, I don't know, you mention a name, and suddenly that name has to be a prompt to me to stop the conversation, run over to the side and do something, right? And then come
right.
back and try to remember where we were and continue on, right? Exactly.
I have that. I'm sitting in front of my computer right now that at the office, and I know that if it's that tool I'm not using enough because it doesn't work into my workflow, it's I don't need that tool probably.
Right, right.
Yeah.
Tough. That's a tough one to solve. And that's only 4 of the 7. So the next one is affordability. And here I want to dispel a myth. There are people who believe, and with good reason, it makes logical sense, that the last thing a law firm would want to do is to replace billable hours that produce revenue with some software tool that, first of all, has a cost associated with it, and second, it eliminates the need for those billable hours. So a lot of technologists think that law firms don't want technology because they don't want to cannibalize their source of revenue.
Mm.
In my experience, that is false. In my experience, lawyers are very happy to use technologies that make them more efficient or that make their lives better and make them happier, make their work less repetitive, so on. But there's a bargain there, which is having spent the money for the software, and if it's going to be built into our workflow, we're going to be now buying it every year. So our business model has to account for a cost that we didn't have before. It would be insane to do all of that unless we're actually going to use it. So adoption is a huge problem in law firms. It is the biggest problem in technology organizations within law firms.
Mm.
Any CIO that you talk to or in a law firm will tell you they would happily trade the next 3 pieces of software they would love to buy and have the budget for 20% better use of the tools they already have within their law firm. So adoption is a huge the So the affordability question really comes down to an adoption question. Can the purchaser be reasonably confident that the software is going to be used by the people who would benefit from it to justify the cost? And there are a couple of things that can make that decision easier because it's a leap of faith.
Mm-hmm.
One way to eliminate the leap of faith is to make the timing of the payment of the software coincident with the benefits that it's intended to bring. So for example, let's say you have a customer relationship management, CRM software, and you promise it's going to bring in an additional $1 million of revenue.
Right.
Great. How about if we pay the licensing fee when we get that additional $1 million of revenue we wouldn't have gotten without your tool, right? So are you really partnering with us, or are you selling us something on faith? Another way to do it is to have, if there's only going to be a small number of lawyers in my firm who benefit from your software, allow us to buy it on a per seat basis, where it's really giving value to those lawyers without charging an enterprise license larger fee that is out of touch with the value conferred to the relatively small group that's going to benefit.
And I have, and we got a couple of questions here that I don't want to interrupt your flow too much, but I do have a question on that. Are you finding that, say, even at a firm the size of Melvin and Myers, are you finding that some of those tools that are, $30 a month, but it's getting used and it's, per user, is that helpful? Are those more helpful? This is just this particular group, the litigation group, they love it. They use this tool. 10 of them or 15 of them want it.
Yeah. If we have a critical mass of people who are using the thing, or a small group that is benefiting in a critical way from a piece of software, then it is absolutely, it's an easy decision. Because remember, we've had to pass these earlier hurdles where software is doing something important and it's doing it, succeeding and it's in the workflow. So sure, it doesn't have to be something that everyone in our firm uses.
And I think maybe I was unclear. Does that individual user selling to you on the individual basis sometimes work better for you than the enterprise licensing agreement?
Sure.
Yeah. Okay.
What's happened is this, and this is particularly true of the legal research vendors.
Okay.
They would have a suite of products that they were offering. And each product only benefited a small number of people. So firm would say, well, don't make us pay for something more than we're going to use. So we want to have 5 seats of this and 10 seats of that and so on. And then I think the providers got nervous that what we were going to do was buy 1 seat and then have 1 person mediate for all the other people in the firm who would benefit from it. Right. And so they switched to an enterprise license where no matter how many people you have in your firm or how many are going to benefit, you're going to pay the same price.
Yeah.
And that has made it tougher for us to take that leap of faith to buy a new piece of software.
That makes sense. Yeah, that's a tough sell for any of us. I mean, that's a tough sell for me in a relatively small company buying a piece of software. Well, if I'm the only one going to use it, so I don't need 10 users. I don't need I need 1 user. That's what I need. So that's interesting. I'm sorry, I didn't mean to get you off on the 7 gates.
It's all good. This is all good. So we finished 5 now. So our 6th one, and it's down the list, but it's critical, is security. And there's not much to say there, except that a cloud-based tool raises security issues greater than an on-prem tool for us. So we will do a security analysis of every software we buy and go through our questions, just as our clients do with us, right? So the security issue starts from the client and works its way all the way down through the people that we work with. And cloud-based stuff just raises more issues because then you have to be concerned that the client's data or any sensitive data could be exposed. And I'll simply say that there is a new project, if you will, not that new, but still kind of getting off the ground, called Rain Court.
Mm-hmm.
Rain Court you could think of as a kind of an app store for cloud-based legal applications.
Yep,
so what they are attempting to do is, to get cloud-based legal technology vendors to go through a process of effectively certifying their technology and getting it to work on a platform that can assure security and kind of a quarantining of that software from other things, so that they can be kind of a good housekeeping seal and the law firm can simply choose applications from their store and not have to go through all of the crazy scrutiny that they might otherwise.
Sort of a third-party vouching for them.
Yes, and both vouching, and they have a lot of technology of their own that, just as Apple has with things that are on the Apple App Store, it is all designed to make the whole thing more secure. Yeah,
excellent.
Yeah. That's a possibility. Yeah.
All right.
And that's 6, and I guess the 7th one, and this is kind of extra credit.
Okay.
So you don't have to do this, but it'll warm my heart personally if you do.
Fair.
So I've kind of reached the conclusion after having done this now for 24 years and kind of beaten my head up against the wall on the problem of adoption of so much of the software within the firm not being used by the people who would stand to benefit from it. So I kind of came to the conclusion that the only way to assure 100% adoption of a tool is to have the software come to you when you would benefit from it, rather than you having to go look for it, even know that it exists. So I'll give you an example. Let's say that I'm working on a case,
Mhm.
and a new judge has been assigned to my case. Wouldn't it be great if an email went to me automatically within a minute of the judge's appointment that said, I see that you are working on this case and Judge Smith has been assigned. Here is some wonderful information about the judge, biographical information on prior cases, motions, statistical information from a variety of sources, all laid out in the email, and with further information if I want to go looking for it. Okay.
Mhm.
So even without my knowing that we had any tools, research tools about judges, let alone these particular ones, let alone how to use them,
Mhm.
at the moment that I really care about this judge, it all comes to me automatically. That is what we are attempting to do at O'Melveny. So we are trying to identify moments in time in a lawyer's workflow that we can recognize have occurred, match them with the best technologies and information sources available to provide the information that would be most valuable at that moment, and then
Mhm.
cause the two to be married and delivered automatically.
And you have it delivered into that horrible, horrible workflow that I despise, the email. But for lawyers, it is where they're living, right? But I mean that's
Literally.
delivered right to you
And the
uh,
lawyer
in
has
the
to
workflow,
scan every email because there could be something, on something they're working on that's critical. So
right?
if I can get the lawyers to recognize that these automatic emails that I'm going to trigger
Hmm.
are going to be really, really welcome and useful, then
Right,
I'll stop and look at those emails when they come.
right.
And that's essentially what we've begun to do. So I'll give you an
Interesting.
example of this. Lexis has two tools that they bought, Lex Machina and Ravel.
Hmm.
And we had licensed both of them, but our lawyers were scarcely using them. Because A, you have to know that we have them. How do they work? How do you find them? And when you're busy and the moment arises when it would be useful, you've long forgotten that we
Hmm.
had such a thing. Now, when the judge is assigned to your case, you get that email and it has links directly into the parts of those tools that will tell you how the judge has ruled on different kinds of motions on a case like yours. So now we're getting much, much higher value from those tools because the adoption is bumped up from whatever it was to close to 100%. So if you can think as you're designing your software, those of you out there on this conversation, think of ways that it can be automatically built into the lawyer's workflow, or a way for the content part of what you have to offer can be delivered independent of your interface, so
Right.
that it can be made part of tools like this that our firm and others are beginning to build. Then you've got big extra credit.
Yeah, that is really interesting. Now, I want to dive in, unpack that a little bit
Sure.
with did you did at O'Melveny, did you guys or your team take from Lex Machina or and create an email system so that that would work for the lawyer? Did you do an API there so that you could kind of piggyback on what they'd already done so that your lawyers were able to see the value in what they were offering?
Right. So we wanted to control the delivery mechanism and the interface completely.
Okay.
So the whole mechanism to identify the moment the judge is added to the case, that comes to our firm in our court calendar system. So we know that that moment has arrived and we know the name of the judge.
Mm-hmm.
We have normalized our data sources so that the names of the judge that appear to our calendar system are the same as the names of the judge in Lex Machina and in Ravel and in all of the other tools that we're relying on. So we
Mm-hmm.
know we're talking about the right Judge Smith, right?
Right.
Then ideally what we'd like to do is to distill the most valuable information that the Lex Machina and Ravel have to give us and deliver just that information, not software.
Mm-hmm.
So rather than a link to a new interface that's going to be foreign and perhaps requires some training, how much better to deliver the bottom line, that would be really useful. And so where we can do that, we do that. And we turn software into information, which is sort of where all this began, right?
Right.
We used to have libraries, right?
Right.
And the library might have 20,000 volumes, but no one had to teach the lawyers how to use the interfaces of each of those 20,000 volumes, because they
Right.
all work the same way. And you had a card catalog, and you found what you needed, and you went on your way, right?
Right.
Well, we've ditched all of that in favor of 20,000 pieces of software, each of which has to live somewhere that we have to be able to find it.
Mm-hmm.
It has credentials that we need to use to get into it. And it has a software interface that's iconoclastic that we have to learn to use it. So in several information-seeking ways, we've kind of gone backwards.
Mm-hmm.
And to the extent I can bring us, back to the future a little bit, it improves adoption of the information, which is the bottom line.
Yeah, that is interesting. So, yeah, give me the information, not the tool itself. The information that the tool provides. Yeah. We have some questions. Adam Long's with us here in the Zoom room. And if you're watching on Facebook, please go ahead and submit your questions as well. See Diego Alcala is over there. If you have questions, please go ahead and share those, Diego. Adam has a question. He asks several questions here. Can you talk about what your constituents, the lawyers and staff at OOM or OMM, are saying are their biggest problems right now? Are there any items that are really, this is what I'd really like to have solved by a piece of technology?
Well, we have 775 lawyers, and you get 775 different answers.
Okay.
But there are themes. One theme is just the deluge of information. So in some sense, we need that deluge, because somewhere in that deluge is something we desperately need to know. But separating that from all the rest is a challenge that has not yet been satisfactorily met by all the filtering tools that are out there. Mm-hmm. So that's one thing, right? And you could talk about using Slack or something instead of email, but that's simply replacing one communication medium with another. And in some ways, it makes the problem harder, because then you have more places you have to check in, right? So, yeah. So that's a common refrain. Another thing is simply, our world has become much more competitive. We are not only competing with other law firms, we're competing with alternative legal service providers, and we're in some cases competing for work with in-house legal departments that are getting bigger. So we have to constantly, improve our game, make ourselves more efficient, deliver better capabilities, all of that. So efficiency is a huge need, but it expresses itself differently in different groups and different practices and so on.
Yeah.
Some of our lawyers want to find a way to look around corners, to identify the next big type of class action or something, mm-hmm. or something that we can anticipate, so that we can help our clients to avoid the risk, or to be prepared for it, and so on. And so we're always interested in tools that can do that. There are probably many others that just aren't coming to mind.
Just don't come to mind right away. Sure.
Well, I'll say that we early on, we made the decision to go with an approach, the long tail approach. If you're familiar with the long tail from online shopping and so on,
yep.
Where you seldom disappoint the information seeker, because everything is available to them. And then we use faceted search to quickly go from the huge body of information down to the individual item that one cares about. So because we did that well, we are able to clear a huge amount of information within our law firm. Mm-hmm. So the questions that come up are the ones that remain after all of that.
Okay. That makes sense. On Adam asks another excellent question, and he does some consulting in this space, so he has a lot of good questions on this. Can you say more about creative pricing strategies that you've seen?
Sure.
Charge based on value, cost savings, anything like that, and have any of those really caught your attention and you found them useful?
Well, you mean from the perspective of the software vendor, not from the perspective of our pricing to our clients?
Right, the software vendor to you.
Well, yeah, a few. Early on in the e-discovery area, as an alternative to a law firm buying its own e-discovery contract or document review tool, there are third parties that would offer their platforms for rent. And so you would put the client's documents on that platform and do all of the review and searching and so forth, and delivery of relevant material. And that cost, that rental cost would be charged through. So that kind of an approach, makes sense, because it is looking for things where the client thinks there is enough value to be willing to pay the out-of-pocket cost for the use of that technology. That's a decreasing area over time. And so much of what we used to pass through to clients based on our cost is now baked into our overhead.
Right.
So that's seldom seen. Tools that allow us to, the per seat approach, I think is still useful. So tools like Contract Express that are only charging for the people who are creating automated documents, or tools like Kira that are charging based on the number of extracted provisions in a due diligence review, from machine learning. Those are interesting because they directly tie the cost to the value conferred on the law firm. Yeah, I will say,
that is creative. The clauses extracted. That's interesting.
Yeah, so that if let's say you're a law firm that has a big project where all they're going to do is try to find a LIBOR provision in 10 million finance documents. Well, then rather than charging them by the document, you charge them by the provision, and it's not so horrible,
Right.
But I can tell you that there are vendors who will occasionally say to us, "Look, we'll give you the first 6 months free, and then you pay." And that's nice, that's great, except that if we're going to ultimately have to pay at the end of that 6 months, then we have to know before we start that we're going to want to pay when the payment starts.
Right.
And so that arrangement is not a substitute for all of the passing through the 7 filters that I mentioned.
Right.
Determine if it ultimately is going to be good for us.
Yeah, and then for 6 months you're worried about adoption as well right? Is it we're going to have to pay for this 180 days and nobody's using it.
Right. So we will turn down what appears to be, at least for a period of time, to be a freebie, because it's not really a freebie. Even apart from the fact that ultimately it's going to start a license fee, there is the really enormous attention cost within our organization to have our IT people become familiar with it, our security people, pass through all the tests, try to get our lawyers' attention, which is very scarce, and try to build it into their workflow and institutionalize it. And if ultimately it fails, then it is, diminishes our credibility as IT folks within the organization. So there's always a cost.
Right. Yeah, because then now I've got a really great one that I want to pitch you that I think we should use, and that last one didn't work out so well, Jeff. Okay, I see that.
You only get so many of those before you know.
Adam asks, what a really great question, because we've got some friends who are in-house counsel, and we hear these stories and I read these stories regularly, but I don't know what your experience is. How much of the tech that you're using has been demanded by, say, general counsel at one of the Fortune 500 companies? We've heard stories that some of these in-house counsel are demanding, look, if you're going to use a tech, we want you to use this one. Is that common? Is that a trend?
No, I don't think that is common. To the extent it occurs, tends to occur in e-discovery, where a client might want to have all of their e-discovery work done on the same platform across multiple cases and law firms or something, or they may have preferential pricing with a vendor for work. Otherwise, while our clients are interested in the fact that we use technology, and one of the things that makes us appealing is that we are constantly seeking out ways both to be efficient in the way we do their work and also to do it at the highest quality because we have capabilities that are brought about by the technology. In 99% of the cases, clients will not say, we think you ought to use this technology or that. They are more interested in the results, which kind of speak for themselves, than in the particular method we use to achieve those results.
Okay, that's fair. You had, and I don't want to keep you all night. I see that we're at 6:42 here, but you did in our email communications before, you had mentioned you had a couple of ideas on what makes adoption easy and what makes adoption hard. I think we may have covered some of those, but was there something else that you had in mind that made it just really smooth, and others that are just too complicated, it's not worth it?
If I think, lawyers are human beings and rational creatures and tend to do things that are pleasure-seeking, organisms. And so things that simply make their day better will tend to get adopted and noticed. And things that are very simple and can be easily consumed and found and all that stuff, will tend to get used. Things like enterprise search, for example, are enormously well adopted because they can be used in so many ways to do things that otherwise couldn't be done. But beyond the most obvious cases, I kind of reluctantly came to the idea of the information finding you, the technology finding you at the moment you need it, even if you don't know it exists.
Right.
Because I think adoption is just very, very, very hard.
Yeah. I like your workaround. I mean, that's for the adoption. Here's what you've built over on this one side, but you've got this workaround that delivers that into the place that they need to check into their
And I would guess most of the people on this call are not old enough to remember the mistake Microsoft made with something called Clippy.
I remember it. It was young, but I remember.
It gets kind of a grimacy smile because Clippy was Microsoft's attempt to do just that, to see that you were in the middle of a document,
right,
and you were trying to use some feature, bullet points or something, and Clippy comes to the rescue, pops up on your screen, and offers to help you with your task. And 99 times out of 100, you didn't need Clippy or want Clippy. Clippy was just a distraction that got you out of your conversation with the software.
Right.
You had to figure out how to swat it away. And if you had time, you would try to figure out how to swat it away permanently, but it was hard to do that.
Right.
Eventually, Microsoft got so many complaints that they permanently removed Clippy from their software. So if you're going to try to marry moments in a workflow with tools or information that would be useful in that moment, you got to be awfully sure you're not being Clippy.
Yeah, that's interesting. And again, it really drives home the idea for me of your workaround to take that information that's made available by the software and just reroute the delivery.
Yeah.
That's interesting. Jeff, just because I have to, because I talked to you about it beforehand, and this is generally supposed to be more of a fun show anyway. You've given us so much great information, but I was so excited when I found this about you being a magician as well. So, I mean, I was so excited about it because it's really what I really like about interviewing folks is I hear these great little stories. Can you tell us a little bit about your experience as a
Oh my
magician
God.
and a photographer as well?
Well, I've been a magician since I was 7, and I just, I mean, the people who design magic tricks are just the smartest, most devious people on the planet. And I find magic gets people off of their game. It takes you from a place where you think you know what's coming to a place where you realize that there's more out there than you anticipated. And that turned out to be really useful working with lawyers who are always sure when you begin a presentation to them. They're always sure they know where you're going. They're ahead of you, and they probably are, most of the time. If you can get them a little bit off their seat, it helps. And lately, photography. I've become a fine art exhibiting photographer.
Oh, no kidding.
And it's kind of like the technology thing. It's taking the chaos of the world and trying to organize it and produce something that makes sense, just as knowledge management is trying to take the chaos of the information in a law firm and
Right.
make sense out of it. So maybe I'm really doing the same thing in all these guises of my weird personality, and they go by different names, but it's all the same thing.
Yeah, it could be all a little bit of the trying to contain the chaos a little bit.
And Arthur C. Clarke, the guy that wrote all the science fiction,
Mm-hmm.
He was a technologist. He invented the communication satellite, and he famously said that any sufficiently advanced technology is indistinguishable from magic.
That's right. That's a great line too. I always forget that line, but it's really true. So I thank you so much, Jeff, for being here. Adam, thanks for your great questions in the chat. Thank you to anybody watching live in the Facebook group. Jeff, don't disappear when we hang up, but I do want to ask you to let our listeners, our replay viewers, and our podcast listeners in the near future, next week that'll be out, the podcast version. But how do they get in touch with you?
Sure. And Nick, thank you very much for inviting me.
My pleasure. I'd love to have you back in the future if you're willing.
And thanks to those both on the Zoom, but also maybe later in the podcast for bearing with us and for undertaking the difficult task of creating the software that we desperately need. So thank you. So I'm easy to reach. My email is jrovner, ROVNER, @omm.com. And if you want to look at photography, jeffrovner.com will show you more than you want to see.
I did find the jeffrovner.com on Twitter when I got excited over wanting to know more about the magic. So I thank you so much, Jeff. Thanks to our viewers and our replay viewers and our listeners. So we'll be back actually Saturday noon. We will have another live show because we're having TryDefine.com startup out of the UK. So we had to make some hourly adjustments for the time difference. So we will have a special episode 91, this upcoming Saturday. We will see you then. Have a good evening, everybody.
Thanks all. Thanks, Nick.